Hello friends, welcome back to VOW DAYS. Welcome to the mains test series discussion. So as you all know, we are discussing the first test and this is part 4 of the first mains test. And in this part, we will discuss from question number 16 to question number 20. Now let's quickly begin. The 16th question, it is on the Constitution of India. It is directly on the Constitution of India. And despite, if you see, every once in a while question will come with regard to comparison of constitutions and all. Last year in 2022, there is a question on the comparison of Indian constitution and that of, Indian president and that of the French president, so like that. So this comparison of constitutions topic is very important both for prelims as well as for the mains. So Indian constitution, if you see some of the important features, it is the lengthiest constitution, lengthiest written constitution. In fact, it had various provisions taken from various constitutions like US, UK, Australia, all of these countries like even Ireland, Germany, South Africa, Australia, like that. And also the constitution is supreme in India. The constitution derives its power from the people, which is given in the preamble. The constitutional sovereignty is there. Indian Parliament cannot give itself a new constitution. So the Supreme Court has placed various limitations for like the basic structure. We have the fundamental rights to the people of India. These fundamental rights are the restrictions on the government. Even the fundamental rights are not absolute, they have certain restrictions, unlike USA where they have the fundamental rights which are absolute. In India they are subjected to certain restrictions. And also Indian polity, if you see, it's a federal system. It's a quasi-federal to a certain extent, you can say, where the power is leaned towards the center, and the unitary bias what we have is because of the various conditions, the local conditions. So here you can get examples, the Schedule 5, Schedule 6, Article 371 and all. And also if you see even judiciary, we have a judiciary where the whole system is integrated. It's an integrated judiciary, unlike USA. In USA the judiciary is not integrated. The state and the center they have different courts. The state and at the state and center level different courts are there. And also our constitution is a blend of rigidity and flexibility. Here you can give various examples like the Constitutional Amendment Act under Article 368, so that gives a bit of rigidity, but whereas we can still amend all the articles, most of the articles except few mentioned under the basic structure. So that also we can give an example. So it is a living document. And also we have directions to the government, instrument of instructions to the government under the DPSP, where we thrive for social economic justice, ensure that there is a balance in the overall ecosystem. And also there is this limitation of power under Article 50. There is separation of power between the executive and judiciary. There is respect for the international laws. It also provides for duties to the citizens. This also we can add, the duties to the citizens, the fundamental duties. Though they are not enforceable by the law, but still they tell the people what is their role as a citizen. All of these things we can write. Now let's move on to the next question, the 17th question. This is with regarding to the ministries in the government of India. So as we all know, we have various ministries that are created by the president on the advice of the prime minister under the government of India allocation of business rules of 1961. And these ministers will be in place only till the time they enjoy the confidence of the president. So that means till the time the president wants them, they will be in place. If the prime minister tells the president to remove that minister, then the president will remove that minister. That is there. So what are the reasons for the creation of these ministers in Indian system? Why we need more ministers? The first thing is diversity. India is a very diverse country and it has various diverse needs. For example, the Northeast, for example, the other states, the SC and all. And also it eases, it is for administrative convenience, it eases the governance, where we can write the Minister of Consumer Affairs, Food Distribution and all. And another thing is that if the power division is not done, it becomes more complicated. That we can write. Okay. And also the functions performed by the government are getting more specialized. For example, new and strategic tech division in the Ministry of External Affairs. So like that we can write all of these examples. Right. Now, are there any limitations? Are there any issues? Yes, there are various issues. Like if you see, The various issues like the coordination will become an issue between the ministries. And another thing, the funds allocation and all, that will be major issue. The funds, how they can be allocated and all. And when there is increase in the government machinery, the red tapeism will increase. That is also there, the red tapeism. And also lot of money will go for salaries and pensions. That is also another issue. Okay, and another important thing is that the government becomes competitive to private sector like the BSNL, LIC and all. And in the era of this coalition politics, the ministries are used as allurement for allies. This is also another issue. Because of this, we can see these kind of crony capitalism, everything, the corruption in politics, crony capitalism, all these things will come into picture. Now let's move on to the next question, the 18th question. This question is on the role of UPSC constitutional provisions to ensure its impartiality. The Union Public Service Commission of India is a constitutional body. It's a central recruiting agency, and under Article 315, it is a watchdog of merit system in India. So this can be a standard introduction which you can use. Now what are its duties? The various duties are conducting exams for the appointment of various all India services, central services and the public services. It renders advice on service matters and is consulted by the government in deciding the disciplinary matters. So it is consulted by the government in these things. It assists the state in framing and operating schemes of joint recruitments. Additional functions relating to the services of union can be conferred on the UPSC by the parliament. It also appoints officers through the interviews for lateral entry. So all these are the major or you can say important duties of the UPSC. But there are some experts who argue that UPSC has certain limitations. What are the limitations? So the recommendations are only advisory, then they are not binding on the government. They can just advise the government. And also the government can make rules which regulate scope of advisory and functions. So there will be an element of risk always in that condition, because the government asks the UPSC not to do certain things. The UPSC has to follow the government orders, and the UPSC is neither consulted while appointing the personnel to different posts on temporary jobs, nor while making provisions for any kind of reservations. And the president also can exclude post, service and matters from the purview of UPSC. All the appointments and all, they will be done by the Department of Personnel and Training, DOPT, right? And the role of UPSC in disciplinary matters has been affected by the emergence of CVC, because the CVC is not taking care of all these things, right? So these are the important things. And there are various provisions with regarding to the functioning of the organization. Article 316, 317 with regarding chairman of the Public Service Commission, 318 regarding condition of service, 322 regarding salaries, 319A with regarding to the eligibility post retirement and so on. So these are the major provisions. So just remember Article 315, 316 and maybe 322, 319. If you can just remember maybe 2-3 articles, that will be enough for your answer. Now let's move on to the 19th question. The 19th question is on the tribunals. The tribunals, they talk about the difference between Article 320. So here the question talks about the difference between Article 323A and 323B. So tribunals, if you see, they are the quasi-judicial institutions which are established by the law to reduce the load on judiciary for faster adjudication, and also to bring in the subject expertise for technical matters. This is the major thing. In 1976, Article 323A and 323B are inserted into the Constitution by the 42nd Amendment Act. This is the important thing. You have the Administrative Tribunals Act of 1985, which authorizes Government of India to establish a Central Administrative Tribunal and State Administrative Tribunal. It makes provisions for setting up of joint administrative tribunals for 2 or more states. So these are the important things. Next, if you see the major difference between 323A and 323B, the 323A, the tribunals for public service matters only, but Article 323B for matters of other things like taxation, forex, land reforms, rent, tenancy, etc. So 323A only deal with public service matters, but 323B deals with other matters. This is the major difference. And the tribunal under 323A can be set up only by the parliament, but under 323B it can be set up both by the parliament and state legislatures. That means the tribunal can be formed under the state legislature as well, but the public services can be formed only by the parliament. That is the basic thing. Okay, and Article 323A, if you see, there will be only one tribunal for the center and one for the state, or two or more for states can establish a single one, and there is no question of hierarchy of tribunals, whereas under 323B there is hierarchy of tribunals and that can be established. That is these are the major differences. In Chandra Kumar case of 1997, Supreme Court declared that the provisions of these two articles, which excluded jurisdiction of High Court and Supreme Court, is unconstitutional. Earlier it was said that the courts cannot interfere, but the judicial review is part of the basic structure. Judicial review is part of the basic structure, and also Article 142, Article 136, they empower the judiciary. So judiciary has all the powers. Okay, and also next you have the Income Tax Appellate Tribunal, which is created in 1941 to reduce the pendency of cases in the courts. After the insertion of Article 323A and 323B, several tribunals like the Central Administrative Tribunal, the sector specific tribunals were set up from 1980s to 2010, and the Finance Act of 2017 consolidated several other tribunals. Okay. So this is about the tribunals, Article 323A and 323B. Generally in these kind of things we have to be very careful. So when they ask for comparison, if you have at least 4 to 5 points, then always use table like this. This will become easy for you. Right. So next one, the President's Rule. So President's Rule, Article 356 and Article 365. These are the two articles that we have. So you can directly start with the President's Rules. The definition: suspension of the state government and imposition of centre's direct rule is nothing but the President's Rule. The Government of India takes direct control of the state and the governor becomes the chief executive of the state. The state assembly is either dissolved or prorogued. It forces the election commission to conduct a re-election within 6 months, and the maximum time for which a President rule can be imposed in a state is 3 years. But beyond 1 year, the election commission has to certify that elections cannot be conducted. Only in that condition the President rule can be extended from 1 year to 3 years. So President rule can be imposed on two grounds. Article 356 talks about failure of constitutional machinery. Article 365 talks about the President getting powers due to this. Already we have seen this in the prelims also, due to various reasons like the hung assembly, when there is no clear majority, when the coalition government breaks down, when there is no confidence motion passed. So various reasons like this. And what is the procedure? The procedure, if you see, the President will proclaim the President's rule in the state. So then immediately the state government will be suspended, but it will not be dissolved. Remember, initially it will be only suspended, but after passing of this resolution by the Parliament within 2 months, then the state government will be dissolved. The state assembly in fact will be dissolved. You have to remember that, and it will be in force till 6 months. Post 6 months, again the resolution has to be passed by the Parliament, or the elections has to be conducted. So these are the various things. And effect of imposition of President rule, if you see, the government, as I said, will be suspended. The governor will become the head of the state, the governor. So all the bills will be reserved to the President, and the Parliament can make laws with regarding to the state subjects. And under the 44th Amendment Act, the 44th Amendment Act basically said that such a proclamation can be challenged in the court of law to check its misuse. This is even confirmed by the S.R. Bommai case. The Supreme Court held that the present proclamation for the state emergency is subject to judicial review, because the judicial review is part of the basic structure. Okay. So these are the various questions of test 1, mains test 1. So this is completely on the static polity. So hope you have enjoyed this lecture. If you have any questions, do let us know in the comments, and try to gain maximum through these lectures. Okay. So that's it for the day. I'll see you again tomorrow with 5 more questions from test 2. Till then, keep studying and stay tuned. Jai Hind.